Hi guys, Peter McKenzie here, Rincon Property Management. We wanted to make another video with kind of the latest updates related to all the COVID legislation that's coming out. So today we're going to talk about Senate Bill 91 and the Tenant Relief Act. So this is, for all intents and purposes, kind of an extension of Assembly Bill 3088. This is a state of California bill. The last video we had was a federal bill. This one's more pertaining to the state of California. Just a quick overview. So the law was just signed by the governor, I believe January 29th, so a little over a couple of weeks ago. The bill extends the COVID-19 Tenant Relief Act, the Eviction Moratorium, and then it also adds some new tenant protections, and then a new program we're excited about on some actual financial rental relief from the government as well. So let's get into it. So the eviction moratorium is basically, the previous moratorium was extended to January 31st of 2021. This new bill extends that to June 30th of 2021. So if you have a tenant who's not paying and they're suffering a COVID hardship, you're not going to be able to evict them until at the earliest June 30th. It also extends the notice requirement. So in the past we used a 3-day notice. Now it's a 15-day notice, and it's not just one notice. So there's multiple 15-day notices. We're not going to get into the details here, depending on what the actual situation that you're facing is. So that's one of the changes related to the extension of the moratorium. The other thing that's actually really important is this bill has a disclosure requirement. So if you have a tenant who's behind on rent because of COVID-19, you have to notice them properly about this bill. And the language that the notice needs to be is very specific in the bill itself. So if you manage property on your own, hopefully you belong to like the California Apartment Association, there's other landlord groups that you could belong to that could provide this document for you. But if not, if you look in the bill, it says exactly what the notice needs to be. But you have until February 28th of 2021 to notice your tenants about this. So if you don't do that, there's some question on how effective you're going to be if you do file an eviction, when you're able to, if you didn't follow what the law required you to do. You don't want to be in that situation. It's not crystal clear, but judges, when they hear these cases, have some discretion, and if you didn't hold up your end of the bargain on what the law required for you, that's probably not going to be a positive thing for you, which we would ultimately try to avoid. So let's talk about the best part about this bill is the rental assistance that it provides for both landlords and tenants. So in all the previous bills, there was no actual money to help pay rent. This one there is. So our last president and the current president, they both are passing bills that are going to provide funds. I think the past president was $25 billion, and we'll see what the other one, we'll see what President Biden comes out with. But that money is designed to go directly to landlords to help offset some of this outstanding rental debt. The problem is those bills didn't say exactly how it would work. They just said we're going to give the money to the states and other local housing authorities for them to disperse. So we haven't actually got that information on how it's going to be dispersed, but the state of California, in the form of this SB91, has come out with more information, which is the main reason we're making this video, to keep you guys totally up to speed on that. So we do know that the application period is going to open on March 15th. We just don't know what that application looks like or where to physically go to get it. I'm hoping they give us, at least a few weeks notice to prepare for that. So the way the assistance is going to work is there's two ways. One, if the landlord and the tenant work cooperatively together and they both agree to the program, the funds are going to be up to 80% of the rent debt. And that is going to potentially go directly to the landlord. So it's not going to go through the tenant and then to the landlord. But in order to qualify for that 80% number, the tenant and the landlord have to work together. And ultimately, they're both, I believe the tenant's going to have to sign something, the landlord's probably going to have to sign something, and then they'd qualify for the 80%. The other option is if the landlord says, no, I'm not going to accept 80%, I want the full amount, and I don't want to participate in this program, it doesn't mean that the tenant is just out of luck. It just means that now the tenant can only qualify for 25% of the rent debt, and that money would go directly to the tenant and not to the owner. Then it would obviously be the tenant's responsibility to pay that to the owner, but they would still be far behind on their debt because it's only 25%. Ideally, both the landlord and the tenant work together and they get up to 80%. If they do, the landlord has to agree to forgive the remaining 20%. So that might be a tough pill for some people to swallow. In my opinion, 80% is better than nothing. And if you don't do that and then you want to go after your tenant for the outstanding rent debt, more than likely it's going to be converted to consumer debt, and that is really difficult to collect. I mean, collection agencies, their collection rates are extremely low. I would assume way lower than 80%. So those are the two ways to do it. Something to keep in mind, the law has language in it that if the landlord refuses to participate in the 80%, it's not super clear, but basically it says if the landlord then wants to turn around and sue the tenant for eviction and all the past debt, but they refuse to assist the tenant to get the 80%, that's going to be viewed negatively. So if the landlord says, nope, I don't want anything to do with it, just know that when the time comes for you to file a lawsuit against the tenant, that is not going to go in your favor and it's going to be viewed negatively. It's a little vague. It's not 100% clear how it's going to work, but if it's in the law, you can rest assured that the judge is going to factor that in. So our advice again is that you cooperate with your tenant to get the most assistance that you can. So who qualifies for the program? So this is pretty clear, and honestly the qualifications are relatively broad, which is a good thing. And I'm just going to read some of them off to you. So one or more persons in the household has to experience one of these things. So either they qualify for unemployment benefits, they've experienced a reduction in household income, they've experienced a financial hardship due to COVID-19, or be able to demonstrate a risk of experiencing homelessness or housing instability. So they have to meet those things. And then there's 3 rounds of the assistance that's going to come out. So in addition to those things, they then have to qualify based on these 3 things. So the first round, the people that are going to get the money the fastest, which unfortunately we don't know what exactly that means, how fast is fast, are people who make less than 50% of the median income. So if your income is less than 50%, you're first in line to get rental assistance. So the second people in line are people that are disproportionately affected by COVID. Not a lot of detail on exactly what that means. And then the third group of people is people who have an income that's 80% of the median income. And those are the 3 people that are the 3 groups that are going to qualify for the assistance. There are some increased tenant protections with the new bill that is definitely worth talking about. One of those is a landlord cannot use the security deposit as rent unless the tenant agrees to it. So the landlord can't just take the security deposit as rent only if the tenant agrees to it. If the tenant has submitted a declaration to you about their COVID hardship, you can no longer charge them late fees. So in the beginning, a couple of the moratoriums prohibited late fees, and then it was less clear as it went on, but this kind of solidifies it. If they've submitted a COVID-19 declaration to you, you can't charge them late fees. And then the third one is a landlord cannot now try to start charging for things that were previously included in the rent. An example would be if you rent a property and the landlord tells you that the water is included in the rent, and now you're not paying the rent, now the tenant's not paying the rent because of a COVID hardship, the landlord can't go, well, the water is no longer included and you're on the hook for the water bill. That's expressly prohibited. So you can't charge for things that were previously included in the rent. I wanted to say one other thing, and that is we are not giving legal advice. We are simply providing information about the law. If you have a situation related to any of the issues we've discussed, I would encourage you to seek qualified legal advice on how to proceed moving forward. If you want to stay up to date on this issue, and there's going to be another video coming out for sure once we get all the details on how to physically apply for the rental assistance program, subscribe to our YouTube page, like our video, or reach out to us because we will be providing more information. Thank you.